Yeah, welcome everybody, and thanks for staying with us. Now it's the DACH panel, so probably the German-speaking, as you said, German-speaking jurisdictions in Europe. Unfortunately, we cannot welcome Simon Planzer on this panel. He is sick just overnight, and he sent me some notes, so I will very briefly summarize on what's going on in Switzerland. And there's something interesting news about the land-based casino industry in Switzerland. We do this later. First, I'd like to welcome the panelists, and I would like to introduce themselves to you, saying the names, what they do, what they know, and why they're here possibly, and then we start the discussion. Bernd, if you start, please.
Thanks, Jörg. Hello, everybody. So my name is Bernd Henning. I'm since 2006 in the industry, nearly as long as Becky Leggero. I started at sports betting, was responsible for marketing, business development, land-based and online. And since then, I've been in various companies and various roles as CEO at Mercure for online casino operations. And now I'm consulting with a small team operators who are coming from sports betting to add casino, or the other way around, or land-based operators to go online, because our industry is changing, the customer behavior is changing, the younger generation is more into social media, and operators have to adopt.
Thanks. Well, next to me, Dr. Christian Rapani from Graz.
I'm an attorney based in Austria, in Graz. We are a boutique law firm specialized in gaming law. I would say 80 to 90% of our daily practice is gaming related. We advise mainly international clients, land-based as well as online, in every aspect of gaming law, from litigious cases in Austrian courts that maybe some of you already had to go through this experience, to regulatory advisory.
Thank you, Mark. Also, Mark Diekmann from Germany.
Hello, yeah. Hello, I'm Mark Diekmann from Germany. I'm in the online game industry since 2005. We were, believe it or not, the first online casino in the regulated market with a German license in these days, from the land-based casino Hamburg and Wiesbaden. We built the first live dealing roulette from this casino, and we make a good business there, and therefore it's a good business opportunity to proceed. We had a long time no German gambling treaty, and this new gaming treaty came up 2 years ago, and then we decided, okay, should we operate or not? And we decided no. We see and we will discuss it today. We have a lot of regulation issues, requirements, and we have to see how we can proceed. Today we are running a new company to bring more gamification tools, to bring more control about players, what they are doing, playing together, chatting, to spend time in a online casino, like a land-based casino, that they have social rooms, that they can communicate with each other, play slots together, tournaments. And we think this is a good step for the German market and the regulated market to bring some new ways of gambling inside the online operations.
Yeah, thank you. That's a very interesting point, and please remind me to touch on this probably at the end of the session or later, before the end of the session, of course. Before we start with our reports about the jurisdictions we are covering today, I give you that overview Simon Planzer provided me with about what's going on in Switzerland. You're familiar with Switzerland. That's not an EU member state, and so far they can do what they want, and there's no control of the European Court of Justice in terms of discriminating rules or in terms of doing unique things. You may be familiar that in Switzerland, an online casino license is only available for those who operate a land-based casino. It works pretty well in Switzerland. In the European Union, it would be an issue because there's jurisprudence from the European Court of Justice that this sort of requirement to own land-based establishment before you apply for a license. In particular, in states where licensing regimes were newly introduced, is seen as a discrimination of the operators from other countries, maybe. But what happens in Switzerland? There are currently 21 bricks and mortar casinos, including 10 online operators. And these licenses expire by the end of 24, which is this year, of course. So the applications to extend these licenses, or even applications for new licenses, had to be filed to the regulator until the 31st October 2022. This, of course, has been done. New licenses will be issued for 20 years, which is quite long. Usually you can see license duration, a period maybe 10, 15 years, but 20 years is quite long and gives you the opportunity to calculate your business on a very stable basis. These licenses will, of course, come into force as of 1st of January 25 next year. The government defined 23 casino zones. That means areas on the map of Switzerland. And among them are 2 new zones, which are around the city of Lausanne and of Winterthur. You can imagine that most of the licenses granted were given to the incumbents, those who owned licenses, who were running the industry, the business successfully and very reliable. The government also added some new licenses, which gives opportunities for international stakeholders for investments and cooperation with the Swiss stakeholders. These 20-year licenses were also already granted if it's only one applicant per zone, because then the decision is easy. Others may have to wait for a while. One exception, the area and the zone of Schaffhausen is still subject to decision making, so no license has been granted so far. Simon also informed me that there were 12 online licenses extended so far, already approved. But those casinos who wish to offer online casino products, they can apply for an online casino license later. There's no deadline, so can do it whenever they want to, unless the license will be expired within 20 years then, of course. As I said before, there might be an evolution, a report of the evolution in 28, which is a standard procedure in Switzerland, just to review the law and see if there's need to adjust it. The government will then decide if they have to change the law, or if not. Experts like Simon Planzer expect no significant changes, which is also a significant indication that the stable law in Switzerland allows the operators really to calculate on a longer basis compared to maybe other jurisdictions in Europe. And this review is normal. It's a scenario that is not initiated by any event or by any surprising behavior of operators. It's just a formal act. Finally, he wanted me to mention that advertising in Switzerland is quite fairly regulated, not as limited as in other jurisdictions. This remains to be the same, of course, only for domestic and licensed operators. In Switzerland, it's fairly liberal. That means the standard requirements, not to fraud, not to target minors, all these standard rules that apply everywhere will also have to be taken into consideration. That's it about Switzerland. We have no significant news about Liechtenstein. And so far, the CH of our topic is done for today. Thank you, Simon Planzer, and hopefully he will have a speedy recovery now. Still not with us, but I'm sending this regards. And we can now then jump to Austria and Germany. As I'm a German host, a gentle host, I'll certainly start with Austria, who's my friend and colleague, Christian. There are a couple of topics I think very important, maybe some regulatory developments, maybe some discussions about loot boxes later, because that's something that really strikes in both jurisdictions, same with Germany, and of course the big topic of player claims. Player claims, you understand, if a player wants to sue the casino, the online operator, and says, I want a refund, I want my losses back because you offered illegal games, it's against the law, it's null and void, and that is a topic not only in Germany and Austria, it's coming in the Netherlands and other jurisdictions. In all these former .com countries where gaming, online gaming was interdicted and offers were available. There is this sort of discussion. But it started in Austria and it's getting worse and worse, but not in every relation. You have maybe some light at the end of the tunnel.
Yeah, I would like to touch on the loot boxes at the very end because that's bad news again. And this is one of the rare occasions this year that I have also good news from Austria, because as you perfectly said, not all good things start in Austria, especially player claims. We've seen this phenomenon now for many years, unfortunately. It's become an industry financed by process cost finances. And how does it mainly work? The player files a data subject access request. The operator, by law, has to deliver the knife the player will later use to stab him, and then file a claim. The claim is based on the argument that the offering was illegal since the operator did not hold the proper Austrian license. That's not possible because there was only one license held by ÖLG. And then in the next step, he is claiming the nullity of the contract, as you just mentioned, and then based on unlawful enrichment, he is claiming back the losses he incurred. As this was such a great business model for these process cost finances and such a lucrative business model, they gave it a try to duplicate this business case and extend it, because in Austria you have to know that games of chance are regulated in a completely different manner than sportsbook. Sports betting is regulated in state laws, in 9 different state betting laws, whereas the Gaming Act regulates games of chance on a federal level. And so now there was this attempt to duplicate the business case and also make it applicable and apply this logic to sports betting losses. And now this is where the good news start. So please remember this moment, the good news start now. There's 3 very, very recent High Court decisions from Austrian Supreme Court and Supreme Administrative Court that stopped this first attempt to duplicate this business model and apply it to sports books. Just in a nutshell, I will just give you an overview of these 3 very, very decisive and I would call them landmark decisions. The one was by the Austrian Supreme Court, and here the attempt was to duplicate the argument used in games of chance cases, saying the operator did not hold the necessary Austrian license for his sports betting offering. The good thing was this argument was not supported by none of the 3 instances. Already starting from first instance with different explanations and justifications, the courts came to the conclusion up to the Supreme Court that it is not necessary to hold an Austrian license if you have no physical presence in Austria and offer inbound to Austria. In a nutshell, if you're interested in these decisions, I'll be happy to give you more insight, but I think this would be far too much in depth for this panel. Then the second decision, or the fronts were twofold. The second front was trying to qualify certain type of bets as games of chance. And one type of bet, the first attempt was, this was an Austrian player doing over-under bets on halftime results, and his lawyers tried to argue that this type of bet, over-under, is per se to be qualified as a game of chance, as the elements of chance predominantly prevail the decision and the outcome of these type of bets. Also in this case, at the end of the day, Supreme Court came to the conclusion a bet is a bet, and a game is a game of chance. You cannot simply mix this up, and it's regardless whether it's on a halftime result, on the end result, it's always a sports bet that has to be seen and looked at under the rules of the 9 state betting laws, and this loss could not be claimed back. And now the last one, maybe it's just a coincidence, but the most obviously economically important types of bets were attacked, because the second one was the combination bet, and up until this very, very recent Supreme Administrative Court ruling, we had to rely on a statement of the Ministry of Finance dated 2010. It was an expert opinion published by the Ministry of Finance stating that a combination of up to 10 bets, no one knows why exactly 10, but it was 10 bets, is to be considered as a sports bet. Combination bets of more than 10 bets, here then the element of chance starts prevailing, and therefore they will be qualified as games of chance. Now we had the case that in Vorarlberg, in the far west of Austria, an operator was fined for offering a combination bet of 12 separate bets, all chosen by the player himself. So first of all, he was fined by the authority. Then he challenged this fine, and already the first court stated that as the bets could be selected by the bettor himself, the skill of the playing teams, the skill of the bettor himself in selecting the bets and in placing his bets, all these together were factors that by far prevailed the elements of chance, and therefore this was a perfectly legal sports bet. And then the Supreme Administrative Court, with some additional arguments, but with the exact intention, with the exact same intention, confirmed this lower administrative court decision. So really, really good news. The main points of attack for sportsbook were now solved in a very, very favorable way by high courts in Austria.
This is because you can distinguish between bets being games of chance and bets being regulated under this unique law in Austria, not treated as games of chance.
Exactly.
That's unique.
Yeah, that's also on a constitutional level. The competence of the legislator and execution and everything is divided between the federal states and the state of Austria.
In 30 seconds, what's the situation in casino games, online casino games? If I, 1 second will do, right?
Yeah. I didn't want to be the guy to be blamed again and the guy with the bad news. Unfortunately, with online casinos, there's cases continue to come in. We've seen a move of several operators pulling out of the market because they could not for themselves, they did not opt to build up even more exposure. Since Bill 55 and the complications in executing titles, we see that the number of cases is diminishing slightly, but we don't see a significant change, to be very honest.
Thank you very much. This was most interesting. We stick to the topic of player claims. And moving to Germany, Bernd, from a perspective of someone who serves as a consultant and is linked to the B2B as well as the B2C industry, what's your take of the situation currently?
Yeah, it's a high uncertainty for the operators who applied now for licenses because they made themselves aware or so they are seen and they are targeted, especially by these lawyers, and especially smaller and mid-sized companies. They don't put money back as a reserve, so there is still hope that some court will rule against it. But it's difficult to say the outcome, and I hope that soonish a court will say, okay, stop this, because there was an intermediary phase, and they applied now for a license, so they are compliant, they are legal. So, and because all those others who are not holding a license at the moment, we don't see those big complaints at the moment. But we discussed also the point with the responsibility or the duty. So if the player is not claiming himself, then you can explain that if the claims have been bought by a lawyer, so then the situation looks different. lucky operators, they can hope that most of the claims from the players will be brought by lawyers or by some associations. So.
Yes, what you mean is we have different kinds of player claims, and the same is in Austria and elsewhere. It started with players seeking lawyers to represent these players against the operators, a normal situation in civil court proceedings. But from time to time it's changed, and now we've seen a very big percentage of so-called process finance companies. They are funding the processes or even purchasing the claims from the players. So that's no longer the player going after the operator, it's the company itself, which is not a good decision for the process financiers, because what they did not took into consideration was that the competence of the court can change. If it's a private person, the player himself, going to court in Germany and suing a casino which is maybe located in Malta, the place of competence for the court is in Germany because it's under consumer protection law. If there's no longer a human being, the plaintiff, but a company, the consumer protection law does not apply, meaning the German court will reject the claim and say, we are not competent, you have to sue them in Malta. This happened now in many, many cases because that was uncertain for these companies, so they have to reconsider their strategy. It's a certain relief to the operators, but of course it doesn't solve the problem itself. The problem itself is like when we talk about casino games compared to Austria, the German courts, I would say 80–90% tend to support the players, legal point of view. If it comes to sports betting, it's completely different because there was a licensing regime in 2012 in Germany that got stuck completely in litigation. It was deemed as against European Union law and not transparent. So there is a solid legal argument that sports betting operators have a better legal position when it comes to court cases. In a few weeks, early May, we are expecting a first decision of the highest civil court in Germany, the federal, what is it called? It's called the Supreme Court, the Bundesgerichtshof. And this court is about to take one of these cases and send out a judgment dealing with sports betting. So this will be, well, expected with a high interest in what's coming up there. And hopefully it will clarify a few things. But if we're talking about casino games, it's still complicated. Another thing which we can discuss is that it's not only the operator sued by the players or the funders, it's also the CEOs or the directors of companies. It's a new trend that they try to go after the company as well as after the directors, say you're personal liable, so we want the money from you, if for any reason it doesn't work with the company. But insofar to spread good news, we've done a few of these cases and we could reject them all. So insofar, none of these attempts to go after directors was successful. So far, cannot predict that this will remain to be the same anytime, but at least this is some good news for those who feel like, as a director, this could cause some trouble. And coming back to you, Bernd, you said some operators, some small operators never considered to do some reserves with the amount on stake. That could be very risky because at the end of the day, we will see a solution that is either yes or no. At the moment, it might be uncertain if any of these highest courts change the situation. But if it all ends up with the losses have to be refunded, then we could see a wave of bankruptcy, right?
Yes, definitely, because for those operators with standalone casinos at the moment under German license, they are not profitable at the moment. So they are waiting for changes of the GGL to allow higher stakes, higher limits. So they just survive at the moment. And if they would be fined or had to pay back huge amount of player losses, then we would definitely see a lot of...
These limit changes, by the way, are subject to discussions with the regulator, the trade associations. The industry is talking to the regulators is listening. There will be an evaluation this year. So I do not expect significant changes. They will not double or triple it, but
Not soon, because they don't
sure.
speak with one voice.
well, the problem in Germany is we have a regulatory body, the GGL, but if it comes to major decisions, they always have to liaise with the administrative board members who represent all the states, and they talk to the regulators, the former gambling committee, and so the decisions were made outside. And even if the regulator understands and says, we should say yes, it can happen that he has to say no, because it's an instruction then. Okay, leaving these player claim topics, just maybe one information. There is one pending case at the European Court of Justice. I think you all know that. It's, I think it's Lottoland involved behind it. It's a case brought to the ECJ from a Maltese court. A player sued the operator in front of a Maltese court. The Maltese judge said, well, this might probably be a question of, well, of an infringement of European Union law. And so we will see how the European Court of Justice deals with this matter, which includes online casino, sports betting, and secondary lotteries. I'm not aware of whether they took it already and will proceed with it, but probably we have to update this. But that's something that led to the effect that some German courts postponed the proceedings, said we stop and wait until we see the outcome of these proceedings. Also something that could be very interesting. Anything else you'd like to add to player claim issues?
Sure.
Please.
As you just mentioned, the direct claims that's purely, or what I understand, at least is my perception, purely to get leverage on the operators and to put pressure on the operators. What is happening here is, in the past, we were very, very successful in convincing and demonstrating to Austrian courts that they do not have jurisdiction in these cases, because these cases are based on tort and not on a contractual relationship. As they are based on tort, the place of damage or the place of the damaging behavior needs to be in Austria. And we could show that when the player sends his funds to top up his credit on his gaming account, maybe to Malta, maybe to Cyprus, to wherever, simply topping up your account does not create a damage in Austria. And with this, in a nutshell, very, very condensed line of argumentation, we were very, very successful up to the second instance courts. Then timing might be a coincidence. Bill 55 kicked in, and suddenly the Austrian Supreme Court turned this around and said, no, we have jurisdiction because an Austrian protective law was violated, and this is the reason why we can have jurisdiction in Austria, and Austrian courts do have jurisdiction. What is now pending with the ECJ is a preliminary ruling request, very, very recent one. I think it's already 2 at the moment. Asking exactly this question, it's about applicable law, but still it's about where is the place of damage and where is the place of the damaging behavior in exactly these cases. And this will then be decisive in if these direct claims pick up pace again.
Any prediction?
Yeah, thinking of how consumer-friendly courts act, my prediction is hard to tell, but I have a strong feeling.
Reluctant.
Yeah.
Right.
We had beginning of this year another court decision regarding the influencer marketing, where they then said, because it was formerly 24/7, it was forbidden, and then they said between 9 p.m. in the evening and 6 p.m. in the morning it would be allowed. But all those social media platforms, they are not built to manage that. So how shall operators who are forced to control it, that their marketing arms are doing it, how can we handle that?
It's not a very realistic approach because it's the internet we're talking about, and there was a total ban for influencer marketing intended and also provided in the licenses. The arguments against this was, well, if the operator controls the influencer and makes sure he's compliant with what he's saying, he's not advertising illegal kinds of chants and things like this, it should be fine. And this discussion is in front of the courts. If we see litigation pending at the court in Saxony-Anhalt, which is close to the place where the regulator is, I'm reluctant to be optimistic because my experience is that this court is very close to the interstate treaty regulation. Probably it's a matter of time, but I cannot predict how this will be ending up. But we see that here and there you can talk to GGL and try to find some leeway of interpretation if you apply advertising rules which are stipulated in your license. And don't forget, many of these license conditions are subject to pending litigation at administrative courts, also outside of Saxony-Anhalt. This is because German operators